Ladies and gentlemen, good morning. My name is Ronnie Hirschenzon. I'm the director of the Official Service Corporate Division. And I'm very honored to open the morning panel, which will focus on the reorganization plan and creditors' rights. It's my pleasure to welcome the first speaker, Professor Alan Resnick from the Hofstra University School of Law. Professor Resnick is also off counsel to Fried, Frank, Harris, Shriver, and Jacobson. He is an editor-in-chief of Collier on Bankruptcy, as well as a previous and current member of various committees and professional seminars. Professor Resnick will present the rules of absolute priority and cram-down, which was mentioned yesterday, was newly introduced in Israeli legislation via the Amendment 19 to the Companies Act. Professor Resnick, please.
The biggest mistake that I have made is agreeing to follow Harvey Miller as a speaker. A mistake I did make once before and I just haven't learned. But I am delighted actually to follow Harvey because of the content of Harvey's speech and what he was talking about. What we're going to be talking about now, this panel, is the plan of reorganization. We're going to talk about confirmation requirements, confirmation standards, the absolute priority rule. We'll be talking about classification of claims. And then we'll be talking about valuation, which is a very big part of the confirmation process. And then we'll talk about the contests that happen during a confirmation battle. I'm going to invite my fellow panelists to interject when they have something to add or challenge me on during the talk. The plan process, and it is a process, is something that I'm not going to have enough time to actually talk about all the details. I did prepare some materials that are available to you on the website. It's called the Chapter 11 Plan Process under the Bankruptcy Code. It's about a 16-page summary, and that will cover some of the things that I just don't have time to talk about. We did talk about several times the question of who files a plan. We know we have the exclusivity period. As was indicated before, there's an 18-month cap on the exclusivity period. That's the period in which only the debtor could file a plan. So the debtor is the kind of the chief architect of what the reorganization plan is going to look like. After a plan is filed, there's a disclosure process. It is very important to the process to be transparent, so that those who are going to vote on the plan have information about the debtor, the background of the debtor, what events led to the debtor's problem and the filing of Chapter 11, information including liquidation analysis, projections, and so on. That's all in a disclosure statement, and the disclosure statement has to be approved by the court before it is actually sent out for voting, with the exception of pre-packs. We talked about that yesterday. There's then, excuse me, the voting process, where the ballots go out with the disclosure statement, with the plan, and there the creditors who are put in classes and the shareholders, the equity security interests who are in classes, get to vote. And after the voting process, then you have the confirmation hearing before the court. I'm now going to talk about a few selected requirements for confirmation. I say a few. The Bankruptcy Code lists 16 requirements to confirm a plan by consent. That is the consensual confirmation. But some of those requirements only apply in specific kind of cases, and we just don't have time to go through all 16. So I selected some of the important ones. The first is the best interest of creditors test, is what we call it in the United States. That standard requires that every creditor who does not vote in favor of the plan is entitled to get at least what they would get in a Chapter 7 liquidation case. That is why you need a liquidation analysis in the disclosure statement so that creditors know if they're going to be getting more or less than they would get in liquidation. Now, this applies whether or not the classes accept the plan. We'll talk about class acceptance in a moment. So even if 99% of the creditors accept the plan, if there's one creditor who says, I'm getting less than I would get in a Chapter 7 case, then that creditor could object and it could block confirmation if that is the case. So that's the minimum financial requirement that you have to pay every creditor, which is why nobody files a plan if it's not going to provide liquidation value. The next is priority claims. You've heard the term administrative expenses. Those are expenses that arise during the case. DIP financing, debtor in possession financing, those are all administrative expenses. That's a priority. Those have to be paid in cash, in full, on the effective date of the plan. There's also certain other priorities, wage priorities. The employees who are owed back wages, they're entitled to a priority up to approximately $12,000 per employee. Those have to be paid in full. The next requirement I want to mention is what we call feasibility. The Bankruptcy Code provides that the court shall not confirm a plan if there is a likelihood that the company is going to need another liquidation, another reorganization in the foreseeable future. That is, the plan has to be feasible. The projections are in the disclosure statement. The projections should give some indication as to whether this debtor will be able to make those payments that they're promising to make under the plan. That's feasibility. The next requirement is that all impaired classes have accepted the plan. Or you have if a class does not accept the plan, there is a possibility of the cram down. Now the goal, it's wonderful to be able to achieve it, is to have what we call a consensual plan. Consensual plan means not that every creditor consents, but you have every class of creditor and equity holder accepts the plan by a necessary vote. And when I say necessary vote, to accept a plan, a class has to accept, if it's a class of creditors, class of claims, you need 2/3 in dollar amount of those claims and majority in number of the holders of those claims of those who actually vote to accept the plan. So, if you have 100 creditors, each owed $10, and 97% of the 100 throw the ballot away in the trash, 2 vote yes, 1 votes no, the class accepted the plan. You only count those who actually vote. Makes it easier to get the class acceptance, otherwise it'd be extremely difficult. Now, hopefully you have all the classes accept, and then, of course, the court can confirm the plan. But, and most plans are consensual. I remember once being on a panel with other lawyers, and one lawyer said, gee, most cases are consensual plans, so cram down really isn't that important to know about. Well, he missed the point. The ability to threat to cram down on a class that doesn't accept, of course, is a very major force in the negotiation. It has a lot to do with the negotiation, the dynamics of the negotiation. Now let's get to the requirements for cram down. That is, if the class, you have a class or classes that will not accept the plan by the 2/3 majority vote. So how do you cram it down? What are the requirements? Well, first of all, you cannot cram down everybody. Congress has determined that you have to have at least one class that's impaired that will vote to accept the plan without counting the votes of insiders. You can't load that vote by having directors and officers in that class. So you need at least one arm's length class to accept the plan in order to cram down others. But then you could cram down the others. There's 2 requirements in order to cram down the plan. The first is the plan cannot discriminate unfairly, no unfair discrimination as to that class that you're cramming down. You could unfairly discriminate against all the classes that accepted. This doesn't apply to the consensual plan or the classes that consent. This is only to the ones that will not. Now, what does it mean, not to unfairly discriminate? Well, basically what it means is that if you have several classes, more than one class, that have the same rank, that is the same priority. So if you have two classes, for example, of unsecured debt, you put the trade in one class, and we're going to talk about classification later. Put the trade in one class, you have unsecured bonds in another class, unsecured banks in another class, assuming you divide them up, and you treat them differently. You give trade 75 cents on the dollar. You give the bonds 50 cents on the dollar. Well, the bonds now say, we're not going to accept the plan, and they don't, and you want to cram it down the bonds. Well, you definitely have discrimination, but is it unfair discrimination? Well, what is the reason for giving the trade more? Do you need to give the trade more so that you have suppliers in the future going forward? And these are the issues that will be discussed a little later by Judge Gonzalez, who will talk about classification. The next requirement is that the plan must be fair and equitable with respect to the non-accepting class. Again, this only applies to the non-accepting class. And what does fair and equitable mean? Well, as Harvey indicated, these concepts, the fair and equitable absolute priority concepts, actually came from the old railroad reorganization cases. That's where it started. And in the old Chapter 10, for example, it required that plans be fair and equitable. And it was fair and equitable with respect to every class. And how did courts interpret what that meant? What did fair and equitable mean? Well, based on the old railroad reorganization cases, Supreme Court cases, and so on, courts interpreted fair and equitable to mean absolute priority. That is, you rank in terms of priority that you would have outside of bankruptcy, and you have to pay the seniors in full before you then go down to the next class. Well, then we had the Bankruptcy Code enacted in 1978, and Congress got a little smarter. They still use the words fair and equitable. It must be fair and equitable as to the dissenting class. But now they put some meat on the bones. They, in a sense, define what fair and equitable means. And it depends on the kind of class you have, whether secured, unsecured, or equity, as to what fair and equitable means. As to the secured class, there are three actual ways to be fair and equitable as to a secured class. And it depends really on what the debtor wants to do with the collateral. If the debtor wants to reorganize and keep the collateral, keep the equipment, whatever the collateral is, and cram it down the secured creditor, how do you do that? Well, what you have to do is you have to pay the allowed secured claim, and when I say allowed, that means up to the value of the collateral. So if you have a secured creditor owed $1 million, collateral's worth $800,000, that is an allowed secured claim for $800,000. And if you want to cram it down, you have to pay that creditor in cash, cannot buy them off with stock, in cash, the allowed amount of their claim, in full, that $800,000. But you could defer the payment. You could pay over time. So that if you have a secured debt that's due in a month, you want to stretch it out and have it due in 5 years under the plan, you could do that as long as the present value of those future payments is, in this example, $800,000. And how do you present value it? Well, you have to pay interest, market rate of interest, not necessarily contract rate. So what you can do to the secured creditor in that situation is stretch them out, defer the payments, use a market rate of interest, and pay them in full on the allowed amount of the secured claim, and the secured creditor retains their lien on the collateral while those payments are being made. Not an easy thing to do for the reasons that Harvey discussed. Now, if the debtor wants to or is willing to sell the collateral under the plan is going to sell the collateral, that you could do, but the secured creditor has a right to credit bid, and they then have their lien placed on the proceeds of the sale. So if the collateral is sold, they get a lien on the proceeds. They could credit bid at the sale if they would like to, and that's also fair and equitable as to the secured creditor. There then is in the Bankruptcy Code these words. Another way to do it is you give the secured creditor the indubitable equivalent of its secured claim. And what does that mean? Well, it's very narrow. That is, if you decide, gee, I just want to give the collateral back to the secured creditor, well, that would be the indubitable equivalent. Here, secured creditor, here, come take your collateral. But other than that, it's very rarely used. Usually these first two methods, either you're going to You cram it down by paying over time and keeping the collateral, or you do a sale. With respect to a class of unsecured claims, and this is really where the absolute priority rule comes in, how do you cram down an unsecured class? Well, either you pay them the allowed amount of their claim in full in property, which means you can give them cash, or you can give them stock, or you can give them anything else. I mean, in theory, you could give them 100 cents on the dollar worth of paper clips. Of course, we don't do that. That's not a currency that we use. The common currency is stock. You give them stock in the company. And you may give them a combination. You give them some cash, some stock, that adds up to the value of, the full amount of the claim. Also not an easy thing to do sometimes. It depends on the valuation. We're going to get into the valuation fights a little later. The other way you could do it, you could cram it down the unsecured class, paying them less than 100 cents, but only if you wipe out everybody junior. That is, the equity, for example, they cannot retain their equity, they cannot receive anything. You've got to wipe them out. That's the absolute priority rule. With respect to equity classes, if it's common stock, you could wipe them out because generally there's nobody below them anyway. Preferred stock, if there's a fixed liquidation preference, you may have to pay that in order to cram it down the preferred, or you could just wipe them out. Equity, usually in most cases, is fairly easy to cram it down as long as it's an insolvent company. There are other concepts that I want to talk about. Yep, I want to make sure the right slide's up. Before I close, other concepts that have come up that relate to cram down, to fair and equitable. And there's really three that I want to mention. One is, and this is not in the bankruptcy code, this is judge-made. A plan is not fair and equitable to a class if you're going to pay them less than 100 cents on the dollar and you're going to pay a senior class more than 100 cents on the dollar. So that if, for example, if the secured class, the secured creditor, is going to take all the equity in the property, all the equity in the debtor. And so, they're going to get 100 cents. Why? Well, let's assume that they're, undersecured. They have a lien on everything. Typically the kind of situation Harvey was talking about. Secured credit has a lien on everything. They're undersecured. They're entitled to the company. And there's a consensual plan. They agree to this. That's what they want. But the unsecureds who are getting less than 100 cents, they come in and they say, well, wait a minute. The company's worth more than that. The seniors are getting more than 100 cents on the dollar, and then you have a valuation fight, and that's what Judge Peck is going to talk about in a few minutes. Two other concepts. One, looking at the clock, one is so-called new value plans. Could management, the shareholders, assume this really comes up in closely held companies where you have either an equity sponsor, closely held. You see it in real estate cases where you have limited partnerships owning the equity. Let's assume that the shareholders, they want to keep shares. They want to keep their interest in the company. And they have to cram down the unsecureds, and they can't do it. Why? Because they can't pay 100 cents on the dollar to the unsecureds. Even in stock, they can't do it. But they want to have their own equity interest. Well, what do? Well, they come in, they come up with a plan, and the plan says equity's wiped out. We're going to cram down the unsecureds, give them their 30 cents on the dollar. Equity is canceled. The plan also says, somebody has to own the company. Those who are the old equity now wearing a different hat as investors, they're going to come in and they're going to buy the new equity in the company. And this way they get it. Meanwhile, the unsecureds, they're still getting less than 100 cents on the dollar, and they complain about it. Well, we had a lot of splits in the courts and the circuits in the United States on this, and this finally went to the Supreme Court of the United States in 1999 in the 203 North LaSalle case, where the Supreme Court said, no. If the old equity has the exclusive right to buy the new equity, even though they're putting new money in, it's an exclusive right, then they are retaining something. They're receiving something under the plan. That's the exclusive right to buy. And you cannot do that. But if you terminate exclusivity and you allow creditors to file their own plans, if you have an auction and you let other parties in interest, the creditors, bid for the new equity, that's okay. And if the old equity happens to be the highest bidder, then they could invest and then they could buy back their company, but it's got to be an auction. The next concept I want to mention in about the last minute I have is something that has come up a lot recently. A lot of people think it's kind of a recent issue, a new issue, though it really isn't. That's what we call gift plans or gifting plans. You have a situation where, for example, the senior secured creditors, they have all the value in the company. They have a lien on everything. They're entitled to get everything. But they want management, let's say, to continue to be management. And management owns equity. They have pension plans with equity. They have, from stock options, and they own equity. And they want to keep the management. So the seniors say, well, why don't you have a plan, debtor file a plan. The seniors will get, 96% of the equity. The old equity will have 4% of the equity, and the unsecureds in the middle, they get nothing. We'll cram it down. And the argument is that this satisfies absolute priority because you're really giving 100 cents on the dollar to the seniors, and the seniors taking that money out of their own pocket, that equity, they're the ones that are giving it to the management. Seniors are giving a gift. Now, we all know there's no such thing as a gift in this concept, but that's basically what they're doing. They're transferring value, skipping a class in between. Class in between is not very happy about it. Even though, if you didn't have this gifting, they wouldn't get any money anyway. And so we've had a lot of litigation recently in the United States as to whether or not you could do it. Does it satisfy absolute priority? And we have two circuit court decisions, one in the Second Circuit, one in the Third Circuit, that have basically said you cannot do it. It violates absolute priority. Now, there's a lot of discussion. Harvey mentioned the ABI Commission looking into whether or not the law ought to change to allow gifting. There are those who take the position, and some lower courts take the position that there's nothing wrong with that satisfies absolute priority. And of course, now we have these two circuit decisions that say you cannot do it. I enjoy listening to debates about it, and people say, geez, there's a new problem, a new concept. Well, it really dates back to the equity receiverships. The absolute priority rule actually grew out of attempts by the senior creditors, the secured creditors, to keep management to help run those railroads, and they would pass value down and squeeze out the class in the middle. And that's what gave rise to the absolute priority rule. Actually, there are cases even at the end of the 1800s that have adopted the absolute, then they called it, the fixed principle. They didn't call the absolute priority rule. That's really where it comes from. So it kind of, makes its way around. And so now gifting is a very controversial issue now in the United States, and we'll see what comes out of this and if Congress makes any changes. I think I ran out of my time. I'm up on my time, so I'll turn this over now to the next speaker.
Thank you so much, Professor Resnick. Our next guest speaker is the Honorable Retired Judge Arthur Gonzalez, was brilliantly introduced already by Mr. Miller. Judge Gonzalez currently of the NYU School of Law after serving 17 years in the Bankruptcy Court of the Southern District of New York. Judge Gonzalez had presided over some famous and complex cases such as Enron, WorldCom, Chrysler, and he will discuss the classification of claims. Judge Gonzalez.
Thank you. It's a pleasure to be back up here. I wanted to apologize for yesterday. I didn't realize before I came here that if you put up a power presentation that your image is not on the screen. Had I realized that, I would have eliminated a great deal of the glare you people suffered through yesterday while I spoke from the top of my head. In any event, I'm here, if we could turn to, I'm technologically challenged. Okay, I solved that. 1122 is really sets forth what a plan proponent, I emphasize plan proponent because that's what it's for. The proponent of a plan is what they can do about classification. And Alan mentioned some of the, the role of classification in the process. But if we look at 1122, A basically says, with the exception of what's provided for in B, and I'll deal with that quickly, a plan may place a claim or interest in a particular class only if such claim or interest is substantially similar. So effectively what it's saying, if it's not substantially similar, you can't put them in the same class. So it clearly tells you what you cannot do. What you can do, though, is take a look at this, and most courts interpret this, that claims that are substantially similar, you can, if you have a proper business justification, put them in different classes. Now there's a parameter that prevents the plan proponent from abusing that, and the parameter would be an objection that says you're not in the proper class, you haven't justified it, etc. So there is some tempering of it. So let me dispose then next with B. B is an administrative convenience situation in which there are small claims, small as relative to the size of the Chapter 11 case, in which you can pay a specific amount and they can be different, not substantially similar, and put them there and just dispense with this. So it's an administrative convenience claim. Now going back to A, I want to go through some examples of dissimilar claims that you could not put in the same class. And I think the easiest examples are the secured claims. Hypothetically, if secured claim A had a piece of machinery for collateral, secured claim B has a building for collateral, C has a different piece of machinery than A does, you can see that these claims are not substantially similar because they look to, in terms of recovery, different collateral. So you could not put them in the same class. Same, even if you have the same collateral, but if you have class claim A that has a first lien, B has a second lien, you can't put them in the same class because they have different rights to payment out of that collateral. If you had another situation where you had a bond debt in which the bonds were secured, all of those bonds on a pro rata basis are looking to the same piece of collateral. The bond holders are looking to the same piece of collateral. There is a situation where you would put them all in the same class. However, very often in a secured class situation, you end up with one member in the class. All right. Moving to the more creative aspect of this, I think, is the unsecured claims. When we look at unsecured claims, those that are clearly dissimilar would be the priority claims. You wouldn't put a priority 1 claim in with a priority 2 claim. You wouldn't put a priority wage claim in with a general unsecured claim. They are unquestionably different and cannot be in the same classifications. The real area, I think, of creativity and flexibility for then the plan proponent are the general unsecured claims, in which if you can articulate a proper business justification, most courts would then accept that separation of claim. There is a very narrow view, and I don't know if there's any judges still sitting that would follow this view, that would argue that if it's substantially similar, so it has the same right of payment against the estate, regardless of whether it's a trade claim, whatever justification you may have, a bank claim, bond claim, etc., as long as it's all unsecured and only has that claim, that right of payment versus the estate, you must put them all in the same class. I don't believe there's much in the way of jurisprudence that's around today that would support that notion, but I'm not sure. But it is out there, or at least was out there. But let's move to the, the more practical aspect of this, which is, I think, is the certainly majority rule today, is that if you have the proper business justification, you can separately classify similar claims. And what may that justification be? Well, you may have a situation where you have general unsecured trade claims, you have, let's say, bank claims. You want to pay because you think from a business standpoint for realization, maybe the trade claims in cash, where the bank claims, you may want to pay them by way of a note. Now, if you put them all in the same class, what would happen? Even if some of the banks agreed to get paid in a note, any individual bank in that class who wanted to get cash instead of a note would have a right under 1123A4 to object and say, A4 says, unless I consent, if I'm in a class, I have to get the same treatment. So the flexibility then exists that if you could justify, from a business standpoint, the separate classification, you would be able to put the banks in one class and trade in another, and pay the trade in cash and pay the banks in notes. And to the extent there was a dissenting group, I'm assuming that the banks as a group consent to that, except there's some minority group, minority banks that don't. That minority group within that class that didn't agree to take notes instead of cash could not argue unfair discrimination because its class accepted the plan. So it gives you that level of flexibility that you wouldn't otherwise have. It also, in certain circumstances, I was talking about consenting classes, it may give you a situation in which you could put claims, trade claims in and pay them more value than you were going to give the banks, and you may be able to justify that. But let's assume the bank group opposes that and they don't consent. Well, now you're in 1129B in cram down, and if you could justify the classification, you'd be faced with a number of other objections, including unfair discrimination. Maybe you would be able to prevail, maybe you wouldn't be able to prevail. But even in that situation, it may be assist in the process by having that flexibility. The other area where you see the, the plan proponent making adjustments to these classes is under the cram down, and because cram down, as Alan said, requires at least one impaired class to consent to the plan. So if you could justify through a business analysis as to why you create this class and separate it from the other similarly situated unsecured claims, you may have that consenting class. Now, it doesn't get you all the way home, but it gets you into 1129B by satisfying 1129A10. Now, once you get there, obviously the plan proponents could object and say it's unfair discrimination, could object on a number of other reasons, but at least you have the flexibility to try to succeed in moving your claim moving your plan forward and in that mechanism. So what I wanted to emphasize is that you have this plan process where the plan proponent can create these classes and justify it. You have some mechanism of protection. You could go to the court and say it was no business justification for the separation. You have a mechanism that if you're within the same class, you have to get the same treatment if you don't agree to it. And you have certain protections. But it's interesting, the flip side of this. And the flip side is that because a plan proponent could justify putting you in a separate class from a business justification, you, a member of a class, you could not necessarily flip that around and say, okay, in this case, the trade claims were put in a separate class and received the same because they were necessary for the reorganization, et cetera. You can't flip that around in the next case and say, wait a minute, trade claims shouldn't belong with all other unsecured claims. You can't use it offensively as a member of the class. So to the extent that a plan proponent can separate classification, doesn't necessarily mean that the law that would allow that business judgment to play itself out be used as a weapon by someone who wanted to force everyone into the same classification. So there's a great deal more flexibility and discretion given to the plan proponent than the objectors in this situation. And so we have this, as I come back to flexibility and the cram down, et cetera, in the plan that's there, and it's there for the purpose of really facilitating the reorganizational process within the purview of the courts and coming to the judge and making sure that it's not abused. Now, one often cry about abuse is the term gerrymandering, and that's a situation where a plan proponent is alleged to have engaged in gerrymandering a class for purposes of cram down. And as mentioned earlier about cram down, a plan proponent may want to do that to create the consenting class. And the gerrymandering is a situation that's carefully reviewed by the court because it is something that can be a very, very strong weapon. Oh, I think I hit the wrong button. Well, Judge Peck, I can't follow you in any way. But in any way, the gerrymandering situation can be a problem. We have to go back to the court to make sure that the plan proponent is not abusing its rights under 1122 by creating a separate classification. And there is a great deal of scrutiny when that class is being used for purposes of cram down, because it will always raise the issue about, is this just a manipulation of the process? But the courts are well-heeled, well-experienced, et cetera, in addressing this issue. And that is basically where I'm going to conclude with 1122 in terms of classification and the process and its role in the bankruptcy process.
Thank you so much, Judge Gonzalez. I'm very honored to invite our next guest speaker, the Honorable Judge James Peck of the Southern District of New York. Judge Peck is a frequent speaker on insolvency law at leading American and international conferences. Judge Peck will present the topic of valuation in bankruptcy. Please.
Good morning. It's a pleasure to be here, and I want to thank Harvey for confirming that I am a mere mortal, and that's, I think, an important framing reference to what I'm getting into. Valuation in bankruptcy is another form of the guesswork that goes on whenever we're trying to value a business. It's just happening in a setting in which there's an arbiter of value, somebody like me, who has absolutely no expertise in the subject. And so one of the remarkable aspects of U.S. Bankruptcy is that we don't have, in most cases, true experts who are in a position to provide objective indicators of value. And I think one of the reasons why that's important is that there's no such thing as an objective valuation, particularly in bankruptcy. At least in my experience, and I have been taught by some of the best people in the field. They haven't been professors, they have been expert witnesses who have appeared in court under oath, all committed to persuade me that their point of view, that their view of value is the one that I should accept. And inevitably, I find, the expert who is retained by the secured creditor has a view of value that differs from the view of value of the expert retained by the creditors committee, and in those rare cases, the view of value of an expert retained by an equity holder. So in a very real sense, we're engaged in what I describe as an educated guess. Valuation is some attempt in a business setting to predict an uncertain future. Future economy, interest rates, prices of goods or services, technological change, political upheaval, whatever may be in the business model is, in effect, an attempt to look at the future and make a guess as to what this business is worth in terms of distributing the available cash, or other resources that the enterprise may have. I am not going to go into the basic valuation methodologies. There are too many financial advisors in the room. And while I do this occasionally at NYU Stern School, I recognize that I am in effect passing on what I have learned by sitting in black robes in my court. But there are three basic valuation methods. One is discounted cash flow. The other is market comparison, in which you're looking at comparable companies. And the third is the precedent transaction or comparable transaction approach. Each of them have one thing in common. They are all dependent upon assumptions. And as I point out in this slide, the devil really is in the assumptions. Are the future cash flows reasonable and supportable? Are the comparisons chosen fair? Is there bias? You bet. There always is bias. In fact, I taught a class at NYU last year. There were about 50, 55 MBA students, and the subject was valuation. And I asked the softball question to the group: is there an objective value for a business? And no hands went up. I asked the next question: well, are valuations based upon point of view and bias? And hands went up all over the room. And this was a group that included a lot of experienced younger people who had been in the business community, and some of them had actually done valuations. And so, at least in our system, valuation is frequently performed in anticipation of litigation. And the litigation is what happens in front of people like me. There are expert witnesses who are retained by the parties. They're generally very experienced at this sort of thing. Their goal is to persuade as to a particular point of view. And the reason is, and it's fairly obvious, if they're right, the party that retained them gets more of what there is to distribute out of the bankruptcy case. And the value proposition that's being advanced is one that may be arising in the context of a contested confirmation. And in effect, what we're talking about here is valuation in a confirmation setting. But that's not the only setting in which valuation comes up in bankruptcy, nor is it what bankruptcy judges typically get to deal with. The contested confirmation hearing is talked about. It's exciting. I've had a few. And I know that it's the sort of thing that professionals would like to avoid, but sometimes relish, because it is the, I think it's the ultimate event in a bankruptcy case. We talked a little bit about the cycle of a bankruptcy. It starts and it ultimately moves in the direction of confirmation. The goal is a consensual confirmation, and Jay talked about that. But sometimes consensus is hard to achieve, in part because there are meaningful disagreements, legitimate disputes as to what the enterprise is worth. And I'm going to mention a personal experience that I've had within the last few months as a mediator. Some of you out there I know were involved in this case. The case is before Judge Drain. It's called XL Maritime. It's a Greek shipping company. And without going into the specifics of the mediation, because that's confidential, I ended up learning some things that bankruptcy judges, when they're sitting and hearing evidence, don't generally get to appreciate. I was dealing with parties who were engaged in active plan negotiations. And one group, the secured creditors, had a financial advisor who was actually in the room and spoke to you yesterday, Flip Hufford. Another group had different financial advisor, that was the unsecured creditors. And in negotiating the plan, the secured creditors believed the company was worth less than the secured claims. The unsecured creditors believed that the company was worth 50% more than that. And part of the problem in bringing about consensus was that these sets just didn't overlap. You had one group saying the business was worth 600 million. You had another group saying the business was worth 900 million. How do you reconcile that? Well, ultimately, an agreement was reached that finessed the value disagreement and provided for various forms of consideration that in effect obliterated that dispute as to value. One of the reasons for compromise is to avoid having people like me, mere mortals, have to decide something, and many of us are not experts in valuation, and many of the experts are extraordinarily persuasive. That leads to a high degree of uncertainty as to what's going to come out of the value dispute. When I was 1 year into my job, I was assigned a case that had been in discovery for 6 years before my predecessor, Neil Blackshear. The case was brought actually by Harvey's partners. It was called Iridium. And Iridium was a startup company, very much like the railroad that Harvey talked about. It was a satellite telecommunications company that was devised by engineers at Motorola. The company went into bankruptcy. There wasn't a lot of value there. And the unsecured creditors sought to pursue claims against Motorola, a very deep pocket, based upon fraudulent conveyance and preference theory. Motorola defended the case on the basis of publicly available market data. They had an expert witness, an extraordinarily persuasive business school professor from Stanford University School of Business, and he wowed me. He provided extraordinarily effective testimony for several days concerning the need to pay close attention to public markets in considering the valuation of a company when considering fraudulent conveyance and solvency questions. And the evidence presented included evidence of publicly traded securities, what market analysts said the company was worth based upon technical information disclosed to the market about what this business could do, and in fact the ability of this company within a relatively short time before its bankruptcy to obtain capital. It went to the capital markets, in effect demonstrating that it couldn't be insolvent. That's not to say that market information is always the right barometer, but at least in my view and in an opinion which I wrote, it needs to be taken into account. Valuation also comes up in ordinary bankruptcy cases all the time, at basically every stage of the case. At the beginning of the case, the use of cash collateral is predicated upon adequate protection. Financing, if it involves priming, adequate protection. An oversecured claim may be entitled to post-petition interest. An undersecured claim may be split between a secured claim and a deficiency claim. And I'm going to talk about an issue that my colleague Judge Glenn, who spoke with you yesterday, is very familiar with. Residential capital was his case. Once again, I was the mediator. It was a very difficult mediation that lasted about a year. The result of the mediation was ultimately a successful confirmation, although leading up to what turned out to be a consensual confirmation were months of incredibly difficult and expensive litigation. The group in question here is a group of junior secured note holders. They claimed that they were oversecured and entitled to post-petition interest. However, the collateral that secured their claim was not so easy to value, nor was it so easy to identify. And one of the items that they looked to, one of the assets that they claimed that they had a security interest in, was a settlement that had been achieved between Residential Capital and its parent company, a company called Ally Financial. Ally Financial, in turn, is a company that had once been affiliated with General Motors and had received significant money from the federal government in TARP funds. So the company that was the parent of this debtor was actually 75% owned by the United States Treasury. It was very important, from my perspective as mediator, to try to get this to the point of a consensual Chapter 11 that would lead to a predictable outcome and that frankly would minimize the burden on Judge Glenn. A very, very difficult case. But for these purposes, which is valuation at confirmation, the real question is, how do you deal with this? How do you deal with the question of whether or not this group is or is not oversecured? I didn't have to deal with that as a judge, but I did deal with it as a mediator. Now, what does a mediator do under these circumstances? For one thing, it's a very enjoyable process to go into a conference room instead of a courtroom, not to have a robe on, and to get down into the process of real negotiation of a plan. And I found that to be incredibly gratifying on a personal level. But I also learned a lot about the motivations and perceptions of parties in Chapter 11 cases, especially large and complex ones, to maximize their recoveries. And every party in interest in a case like this has an incredibly sophisticated financial advisor at its side, advancing an argument that would support why they get more and why another party should get less. Additionally, there are legal claims under our law, such as subordination under Section 510 of the Bankruptcy Code. I'm not getting into that. I'm just saying there are issues that parties can marshal in an effort to improve their position or to diminish the position of their adversaries. And this is what occurs in the plan negotiation process. Finally, I'm going to mention a case that Judge Glenn referenced, decided very recently, within the last couple of weeks, by our colleague Alan Gropper, who has also announced his retirement. Alan Gropper will be retiring in October of this year. The Tronics case, and I'm not going to go into the details of it, is another example like Iridium. It's a case in which the valuation that's at issue before the bankruptcy court doesn't relate to the confirmation of a plan, but rather relates to the determination of whether or not the enterprise in question was insolvent and whether or not certain transfers should be avoided. In this instance, Judge Gropper collapsed a very significant corporate transaction that was entered into by a large company called Kerr-McGee in order to shield part of its enterprise from environmentally infected assets. And so there was effectively a spin-off. What the bankruptcy court needed to evaluate was whether or not this debtor was insolvent and left with unreasonably small capital as a result of that restructuring. Judge Gropper found that, in fact, the transaction was inappropriate given the environmental liabilities. My point is not to review that case as much as to review the process that the bankruptcy court had to go through in order to deal with this kind of a problem. I may not have the right number of days in my memory, but it was something like a 39-day trial that took place before Judge Gropper, involving 16 expert witnesses who testified with regard to valuation. That is an example of how, in our system, value disputes can really get out of hand unless they're settled. I'm going to close, and I have just a few minutes, with some unscripted remarks about the charter. Actually, all these remarks are unscripted, but some unscripted remarks about the charter communications case that Harvey talked about. I think the charter case is kind of a remarkable example of how Chapter 11 can be used to preserve value of an enterprise. And we haven't really spent time talking about the difference between enterprise value and liquidation value. But I think that's an important concept to at least advert to briefly. In every Chapter 11 case, the disclosure statement includes, as an attachment, a liquidation analysis. And the liquidation analysis is a valuation that assumes what the business is worth if liquidated. It's almost always, actually you wouldn't have a disclosure statement unless this was true, it's always worth less in liquidation than it is in reorganization. The value proposition is that, as Harvey said, if an enterprise is a going concern, it will be worth more than if it is liquidated. Secured creditors, by the way, don't always agree with that proposition. But in the case of Charter, Charter went into a Chapter 11 case in early 2009. It was during the height of the financial crisis precipitated by the filing of Lehman Brothers, something I'm going to talk to you about after the coffee break. And it was impossible to obtain financing. Charter had a $12 billion facility of senior secured debt agented by JP Morgan Chase, a facility that could not be replaced. And so the plan of reorganization concept, a fairly interesting one, I think, was to reinstate the $12 billion in debt of JP Morgan. JP Morgan objected vehemently. In order for that to occur, they had to be fully secured and there had to be no defaults under their facility. That's what this bankruptcy was largely about. But there's another component which goes to valuation. Charter was a very highly structured enterprise with a senior holding company and multiple tiers of intermediate holding companies leading to its operating company entities, which were holders of cable company assets. This was a company that was cobbled together by Paul Allen, one of the co-founders of Microsoft, and he was the majority equity holder. At least at one level, and my opinion involving this case confirms this, this was a case largely about the net operating loss carry-forwards, tax attributes that were created in part by the losses of the company and that were designed to benefit Paul Allen individually. I have 2 minutes left, and I'm going to accelerate to try to make this story a sensible one for purposes of valuation. There were bondholders at the parent level of this capital structure who took the position that they received inadequate consideration under the charter plan because the plan failed to deliver to them value attributable to the preservation of these tax attributes, and they were worth billions of dollars. I ultimately found that they weren't entitled to the value that they argued they were entitled to. But we had, both with J.P. Morgan fighting the case and with the bondholders fighting the case, I think it was a 16 or 19-day contested hearing on confirmation. Much of that involved valuation testimony of experts. And so the takeaway from this presentation is that valuation is one of the critically important yet terribly uncertain propositions in every major Chapter 11 case in the United States. And these disputes are best settled, if they can be, as opposed to being litigated to conclusion in front of mere mortals like me. Thank you.
Thank you so much, Judge Peck. Mr. Bernstein will discuss the topic of confirmation contests. Please.
Thank you. And I'm going to try to finish up so that we have some time at the end for questions. I'm very honored to be here, and I actually was also very honored to hear Harvey Miller's presentation, which was a wonderful presentation about the history of our bankruptcy system. The interesting thing about it is we've had 116 years to work on this, and you've got a brand new reorganization law. And I think what this illustrates, what Harvey's talk illustrates, is actually how our reorganization law and how we've dealt with bankruptcy has been shaped by the changes in the economic environment. And it's actually quite interesting, and people have observed that we had a Bankruptcy Act in 1898, another one in 1938, and another one in 1978, 40-year intervals. And one reason the ABI Commission, American Bankruptcy Institute Commission that Harvey mentioned, has been created is to look at whether we need to change in light of the fact that 2018 is approaching and it's another 40-year interval. But that's actually a serious point, because the tensions that Harvey and others have spoken about in the last 24 hours in our bankruptcy system have built up over a period of time. And to my mind, the great tension is not the one over debt trading and debt traders wanting to do so-called loan to own. They buy debt and want to own the company through a reorganization. And it's not even the fact that has been mentioned about our bankruptcy system, our reorganization process evolving into an M&A process. I think the big factor has been the amount of secured debt that we have today that was not true 20 or 30 years ago. Even in highly leveraged transactions, there was always an unsecured set of bonds. And I think those of us who looked at the slides with the last panel yesterday and saw the restructuring that you were talking about here in Israel were in admiration at how much unsecured debt there was, because all of us had the reaction that this company can really be reorganized. And the concern when you have a lot of secured debt is it's very tough to do, as others have explained. It seems to me that there are two issues associated with that, and they bear directly on the question of getting to the confirmation hearing and what the confirmation disputes are going to be. The first issue is, if the value of the company is less than the secured debt, are you going to have enough cash to survive? And Harvey talked about that. And if the answer is no, then it's only the secured creditor that makes a decision about whether to sell or to hold. And it may not be a piecemeal liquidation, maybe a going concern liquidation, but the secured creditor is basically voting its secured position to decide whether it gives you more money to get to a reorganization or whether it insists on giving you only enough money to bridge you to a sale. And the second issue, and this goes to the heart of our reorganization law, is whether the bankruptcy is a day of reckoning in terms of value, really the subject that Judge Peck was talking about. It can be a day of reckoning in two ways. If you don't have cash to survive, then you are valuing the company by putting it up for auction, because you get whatever you get, and it goes only so far through the capital structure as it goes, probably only paying the secured creditor. But the second time that can come up, if you haven't sold the company, is in connection with the plan process. And the ultimate question of when the absolute priority rule is applied, if a class doesn't like what it's getting under the plan, you have a valuation. You determine who the fulcrum security is in the case. The judge decides, and everyone below the fulcrum security does not get any recovery if the fulcrum security hasn't been paid in full. And that is critical because it values the company on a date certain. And it doesn't address the problems that I will discuss a little bit later, embellishing on what Judge Peck has said about valuation uncertainty. And perhaps that's something we need to revisit in a world where there is so much secured debt. So with that, I'm going to start the slides. A lot of this will be things that you've already heard, but it's sort of going to bring together a lot of the issues that we've heard about over the last 24 hours. We talked about the pre-1978 situation where you had the two chapters, Chapter 10 and 11. And under Chapter 10, we had a mandatory fair and equitable test. We had a required valuation because the only way to apply the test was to do the valuation. The SEC, Securities and Exchange Commission, provided reports on valuation to the court. They acted in effect as an expert. And what that led to was protracted litigation in virtually every case over valuation. And some of those litigations took years and years and years to resolve, literally years. Then came the bankruptcy code, and as others have pointed out, the whole thrust of the bankruptcy code in reaction to that Chapter 10 problem was to try to make bankruptcy more inviting, destigmatized bankruptcy so reorganization would be used, and then also to encourage consensual reorganization plans. And the way it did this was it held the absolute priority rule out as a risk because the judge was going to do a valuation and you never knew how the valuation was going to come out. And then people would negotiate against the backdrop of that uncertainty and try to reach a consensual reorganization plan. So the acceptance of the plan, the consensual reorganization plan, in effect, superseded the absolute priority rule as the preferred way of resolving reorganization cases. And it was a tremendous innovation. And in a world where you had lots of unsecured debt, bankruptcy was destigmatized, trustees were eliminated, so it was attractive to go into bankruptcy. You had time to reorganize, and then you would have your plan negotiation and hopefully reach a consensual plan. So that was a fairly clean world. But then things began to get more complicated. Capital structures became more complex, and issues started to arise, even in a world of unsecured debt. One of the issues, the first one there is not in a world of unsecured debt. The first issue is a lien perfected? And very often there will be a dispute over whether the lien is perfected. There are provisions in the bankruptcy code in Section 544 which permit liens to be avoided if they are not fully perfected, if the appropriate filings haven't been made. That is often a dispute at some point in the case. Sometimes the litigation is avoided. Some of the collateral is perfected, some of it isn't, and it leaves an issue at confirmation. If somebody wants to say, we think you were overpaying the secured creditors simply because some of the collateral isn't perfected, that can come up at confirmation. Valuation of collateral, the subject that Judge Peck just discussed, is always an issue. There are questions about seniority and whether unsecured claims are senior to other unsecured claims because of contractual subordination or subordination based on alleged misconduct by one of the creditors, equitable subordination. And finally, if an insider is a creditor, there can be an issue as to whether that creditor's claim as an insider or even as a shareholder should be recharacterized as equity. And these issues, depending on the case, come up if you've got the example of your sponsor situation. If your sponsor is both a lender as well as an equity holder, it's very possible that creditors would challenge the sponsor's right as a creditor and seek to recharacterize the sponsor's claim as equity on the grounds that the company perhaps was too thinly capitalized or the like. Then there are issues about voidability of claims. Now, the way this normally comes up is rather than litigating whether a transfer is a preference, a payment on an antecedent debt during the 90 days prior to bankruptcy while the debtor was insolvent, or a fraudulent transfer, effectively a transfer without consideration or with intent to hinder, delay, and defraud, the way this comes up is those claims may get released under a plan. And the assertion will be made that insufficient consideration is being provided in order to justify granting those releases, so that could be disputed. An example of a case where this frequently comes up is leveraged buyouts. If a leveraged buyout has ended up in bankruptcy, there is almost inevitably going to be an assertion that when the buyout was done and was financed and the money was paid to the shareholders, the company was rendered insolvent by the transaction itself. And that leads to the possibility of two separate defendants. One is to try to pursue the shareholders, and the shareholders may have defenses, which I'm not going to get into now, but the other is to say that the creditors who facilitated that transaction by lending into the company and taking a security interest to secure that loan should have that security interest and perhaps even the loan voided as a fraudulent transfer. And this has been a doctrine that started with a case in 1986 called the Tabor Realty case, but it still comes up very frequently, and frankly with the leveraged buyouts go in cycles, and we had another cycle in the early 2000s. This is something that's actually been litigated very recently. An example of such a litigation is the Tribune case. Tribune is a company that is a conglomerate. It owns newspapers and media interests. And in the Tribune case, the assertion was made that the buyout rendered the company insolvent. We'll come back to Tribune a little in a few minutes. So that's another set of issues that can get litigated at confirmation. Judge Peck mentioned the best interest of creditors test. That is an issue that I think is rarely litigated, though, as Judge Peck mentioned, sometimes a creditor will assert that you could auction the company in a going concern sale, and therefore the test of the liquidation value of the company, which is the value that you're looking to for the best interests of creditors test, is the liquidation value of the company as a whole as opposed to a piecemeal liquidation value. And you'll hear that argument made. I think in most cases, without actually having had the auction, it's very difficult to say that you could sell the company quickly. And the other assertion is that if you did sell the company, the measure of the price for the sale should be what you would have received outside of bankruptcy. And in an outside of bankruptcy situation, if the company didn't have the protection of the court, it would have been a piecemeal liquidation. And then finally, as we've discussed several times now, the whole issue of cram down. So let's talk a little bit more about cram down. And I just want people to understand the dynamics of a cram down fight. Typically, you've got a class that doesn't like what it's received under a plan. If the class is a senior class, you're actually trying to cram up the senior class. You're trying to say you have received enough and we're trying to get value down to junior classes. If it's a junior class, you're cramming down. We talked a little bit about gifting. Gifting, again, is a plan of reorganization where the senior class gives up value to a junior class, skipping a class in between. It seems that the trend of the case law is against gifting, but plans are still proposed in circuits where the circuit has not yet spoken on that issue. So there are two separate valuations that are required for cram down. The first valuation is typically the enterprise valuation. And the second valuation is the valuation based on the enterprise valuation of the particular securities and consideration that's being given to a class. So in one of the examples we discussed before, we were talking about equity going to the unsecured creditors. In that case, you would be looking at the enterprise value, you would be looking at the amount of debt that's being put on the company and what the net value of the equity is. You really need both in order to be able to do the valuation of the securities. If you're giving out debt, you're going to be looking at the interest rate, the maturity, whether it's secured, and whether in fact it's going to have a value equal to its face amount or not. Experts on valuation, again, echoing Judge Peck's theme, they tend to be they tend to be all over the map in these cases. We had a case, the Mirant case, where the valuations of the experts were billions of dollars apart. And that is not an infrequent event. This happens all the time. I have a few quotes from illustrious professors. The one I like the best is by a professor, Peter Coogan, who used to teach at Harvard. And he says that enterprise valuation is an estimate compounded by a guess, an estimate of the projections for the business, and a guess as to the discount rate. The assumptions that are disputed include the business plan, the methodology for the DCF, the discounted cash flow, which companies should be comparable companies and which ones shouldn't, what multiples you should use, should it be a trading multiple, an M&A multiple, which end of the range of multiples should you use, whether there is a bankruptcy discount. This is one that's worth mentioning because there is a line of thinking that when a company emerges from bankruptcy, its value is going to be at a discount to its true worth. I refer to the lemons problem. When you drive a car out of the showroom, its value goes down precipitously because if you try to sell it the next day, someone thinks it's a brand new car. Why does this person want to sell it? It may be worth less than he's purporting to sell it for because he knows more than I do about what's under the hood. And there is some element in bankruptcy of, even if you have a thorough auction process, the creditors who have been looking at the company for a long time and the debtor know a lot about the company, and there's a concern as to whether there is a so-called lemons problem because there isn't enough information about the company. There's also an issue that is more and more frequently coming up, especially in light of the LaSalle 203 North LaSalle decision that was mentioned by Professor Resnick. In that decision, and in other decisions of bankruptcy judges since, there has been an increasing focus on using market evidence rather than expert evidence. Experts testify as to value, but everyone knows that the experts are advocates. The senior creditors are seeking a low valuation so they can get the entire company. The junior creditors are seeking a high valuation so they get some residual value. And what is the best evidence? Is the best evidence some sort of market test, either by having an auction simultaneously with doing the plan, or by looking at what the debt is trading for and what the various securities are trading for as a proxy for the value of the company. And in fact, in a recent case, the Rotec case, there was an auction that was conducted in order to validate the company's view of value, and it in fact did. In fact, no one showed up for that auction. So it made it clear that the company, the junior creditors who were asserting higher values were having more difficulty doing that after the auction. But are auction results always reliable? It really depends on the timing and the circumstances under which you're conducting the auction. Exide Technologies, a debtor that emerged from bankruptcy in 2003, was the subject of a major valuation disputed confirmation where there was auction value testimony, and the auction value was quite a bit lower than the value that the debtor had asserted for plan purposes. The judge confirmed the plan, adopted the value that the debtor had asserted, and subsequently it turned out that the company was worth a lot less. So in a market, under certain circumstances, the company can emerge worth far less than the valuation. It does again call into question whether valuation on a particular day or valuation based on expert testimony or even based on an auction as of a particular day is sensible in a world where there's so much secured debt. In fact, one of the reasons why a judge may be inclined to accept the idea that there is a lemons problem and that the value should be higher is that absent doing that, the secured creditor would walk away with the entire company. There is a difficulty with having a day of reckoning, but that's our current system. Delphi Automotive was an example that went in the other direction. In 2008, automotive-related businesses, and this was a company that supplied parts mostly for General Motors, but also for other companies. The values were incredibly low. And you heard the story yesterday about how even the DIP lenders might not have been paid had the results of an auction that had been conducted where General Motors, a private equity firm, and the United States government were going to effectively buy Delphi if that transaction had been consummated. Instead, the lenders decided that they would not let that plan go forward, and they credit bid their debt. And the company, after bankruptcy, has been incredibly successful. The secured creditors have received more than 100 cents on the dollar by owning the company, and they wouldn't have if the auction result had been simply that the cash bidder would win. If you look at cases, massive changes in value can occur even during a case. So the question is, how do you resolve these valuation issues? My time is up. So I'm going to just point out that there are ways to resolve valuation issues, and this gets to the creativity that some of the other speakers have discussed. If you look at valuation, the dispute between Party A and Party B over a range of values can be resolved by designing securities that reflect the possibility of differences in value and providing the senior creditor with certain recovery and providing option value to the junior creditor. This can be done with warrants, convertible securities. If one of the variables in value is the value of a litigation, it can be done with litigation trusts. The best example I can think of this is actually an insurance conglomerate called Conseco. In that case, there were three groups: the senior creditors who were secured, the bondholders, and then a group of trust preferred holders. And the senior secured creditors were absolutely certain the company was worth $2 billion. The bondholders were absolutely certain the company was worth $4 billion, which would have gotten them the equity of the company. And the trust preferred holders essentially thought that the company was worth $6 billion. And the bondholders and the senior banks got together, and they thought that the trust preferred's valuation was outlandish. But they agreed that there might be a range of values. And what they did was they designed securities in two different levels. senior securities that were convertible to equity. And if those securities weren't redeemed, they would convert to virtually 100% of the company's equity. And then junior securities that went to the bondholders, namely common stock. And the question was going to be deferred until 27 months after the company emerged from bankruptcy. And if in fact the company was not able to redeem the senior security during that period and refinance it, then the banks would end up owning the company. It turned out that the bondholders were right. The company was worth closer to $4 billion than to $2 billion when it emerged from bankruptcy, and the bondholders were able to refinance the senior security and were able to retain ownership of the company. This plan let the market decide and let the option value continue so that the bondholders could get value. There was still a 6-week valuation trial with the trust preferred holders, which the trust preferred holders settled for a small amount of warrants. So they too got a little bit of option value in the end of the day. It's worth keeping that in mind. It's a paradigm that is used frequently if you don't end up selling the company before confirmation. And it's a way of avoiding the day of reckoning and avoiding the problems that that leads to. Thank you.
Gentlemen, thank you very much. We'll take a couple of questions, please, from the audience. Please present yourself, Professor Han, and could you kindly address a specific member of the panel?
Okay, well, thank you very much. I'd like to ask all the panelists, although it goes back to the talk of Judge Gonzalez on classification of claims, an issue that we're having now in Israel, and it's developing over case law, and there's a lot of argument about it. Judge Gonzalez, you mentioned in your talk primarily how you can use classification sometimes in order to separately classify certain claims in order to treat them perhaps differently, and then you can use also the cram down to the extent there are problems with consent. The issue we're having now in Israel is just the opposite. There are cries and arguments that we are too easily classifying too many creditors, especially bondholders, all together in one class. And I know you even wrote an opinion in one of our cases, in the Elbit case, to the corporation who sought your advice how it would be classified had it been in a US court. The issue is, the arguments go that you have bondholders who are private bondholders, and then you have institutional investors as bondholders, and then these institutional investors often also hold stock, equity of that same debtor, and thus they have a different perspective, and should they, given that different perspective, be classified separately and not piled up with the private bondholders. Another argument, even if they don't hold stock of that very same corporation, since most of the corporations, most of the debtors, have a controlling shareholder stepping into the reorganization, and that controlling shareholder often has other businesses, and the institutional investors have business relationship and investments in the controlling shareholders' other businesses, they may lean in favor of a plan which is not really favorable to the bondholders or to the creditors in general, given their ties with the controlling shareholder in his other businesses. And then again, the argument is, well, they should be classified separately. They should not join in with the regular so-called bondholders. I wonder what's your perspective on that. Thank you.
I think, and I was losing my voice, so I didn't cover a lot of this, but if we're looking at a single bond issue, this single issue, and I think you look at the characteristics of the bond issue with respect to the debtor, and if it's, basically all the bondholders would be in the same position. And go back to something I was trying to get across, is the plan proponent then, proposes a plan and puts all the bonds obviously in the same group. Well, someone comes in and says, well, wait a minute, some of these bonds holders may have maybe institutions, maybe have different holdings, may own equity. I really think from a U.S. law standpoint, that's more, first of all, I don't think you could force it, the plan proponent, to do it, because I think that runs into that situation where there's similar claims, and can you make the plan proponent separate them because the objector wants them in a different class. But the other aspect of it is the other holdings and maybe the motivation for voting and things like that. I think under U.S. law is more dealt with in the designation of the vote. That's how they put some parameters around a misuse of or a manipulation of the process by a holder of claims. But I still think if you look back, I'm sorry, the designation of votes would be under 1126E if a particular claim holder or voter acted improperly or acting inconsistent with certain norms that you would have. Let's say a simple example would be a competitor. A competitor holds claims. Competitor wants the plan to fail because the competitor will do better off with its other business. There's a motivation outside of the bankruptcy case context. And so someone would move to ask the court that this voter is acting improperly, designate the votes, which means the votes wouldn't count. So I think if you had it within the context of a bond issue, under U.S. law, you would have to reach that threshold of some improper conduct would then disallow the votes to be counted of the particular creditor that acted improperly because they're acting in some other interest other than their interest as a creditor. But I don't think you could take those bonds and separately classify the holders just because of some other extraneous relationship or other relationship they may have with the case. Because they have the same right to payment within that particular bond.
No? Another question?
You're not classifying creditors, you're classifying claims. And that's why it's the claim that's being classified. And if it's a bond claim, it's a bond claim.
Please.
Thank you very much. My question relies to the auction procedure that you have described. If I understand well, the auction is between the different stakeholders or the different debtors of the company, the different creditors of the company. But do you have a different auction, which is two plans as to rescue this company, reorganize the company? Because under your description, there was one reorganization plan. And within the plan, there is the possibility of an auction of some of the assets in order to understand if the valuation is fair. That's right, if I understood you well?
Yeah, actually what I was...
And my question, if I may interfere, is would you consider having one plan, as you've heard yesterday, one reorganization plan offered by the debtor in possession and another plan offered by someone else, and those two plans being on auction to the creditors, which plans they prefer?
Okay, so I think you're actually asking two questions. The first one was I was really referring to whether you would have an auction separate from the plan in order to see the value of the company. And it's been used as a technique to validate the valuation in the plan. And if the value comes in higher, you sell the company. If the value comes in at or below the plan value, then the debtor would proceed with the plan of reorganization rather than selling the company. But the second question you're asking about competing plans is very interesting. Yesterday we heard that Congress amended the law in 2005, amended the bankruptcy code to limit the exclusive right of the debtor to file a plan to a maximum period of 18 months. After that period is over, and it has occurred in some cases that period has ended, it's possible for creditors to propose their own plans of reorganization, and you can have competing plans of reorganization, and the judge has to decide which plan to confirm.
I'm going to just add a specific example to what Don talked about, and we'll be talking about this after the coffee break. In the Lehman Brothers bankruptcy, the company experienced two competing plans in addition to its own plan. Ultimately, the case resolved around a fully consensual plan, and I plan to talk about that later. But because the bankruptcy amendments of 2005 imposed an 18-month limit on the debtor's exclusive right to propose a plan, and because the Lehman Brothers bankruptcy case was so overwhelmingly large and complicated that it was virtually impossible under any set of assumptions to develop a confirmable plan within 18 months, the company found itself in a situation of vulnerability to competing plans. And there were 3 plans at one point on the table. Only one went to confirmation, and the confirmation hearing lasted less than 2 hours because it was fully consensual. More about that later.
Ladies and gentlemen, thank you very much. Coffee break.